Hello, and welcome to this Lecture Plus for Property Law. This lecture will focus on freehold covenants. It has two parts. In part 1, we shall identify some basic features of the law relating to freehold covenants affecting land, and in part 2, we shall identify how to structure an answer to a standard co-ownership problem question. We shall then utilize that structure to preview an exam question. It's worth emphasizing that the focus of this Lecture Plus is freehold covenants, i.e. covenants which are made between one freeholder and another. Very different rules apply to leasehold covenants, that is, covenants made between a landlord and a tenant. It's very important that you do not confuse these two areas of property law. They are subject to very different rules. This part of the lecture identifies the basic features of the law relating to freehold covenants. Let's start with an example. Imagine that A owns the fee simple estate in Redacre and that B owns the fee simple estate in Whiteacre. Imagine that Redacre and Whiteacre are neighbouring houses. Imagine further that B covenants with A that he will do X or that he will not do Y. For example, B might covenant to trim his garden hedges at least once every 6 months. This is a positive covenant because B is required to do something in order to comply with the covenant. It requires action on B's part. Alternatively, B might covenant not to have any barbecues in his garden. This is a restrictive covenant because B can comply with the covenant by inaction. The covenant does not require B to do anything. Rather, he must simply refrain from participating in a particular form of conduct, i.e. using his garden for barbecues. In each of these examples, B is the covenantor. The covenantor is the person who makes the promise, or, as it is commonly expressed, the person who is subject to the burden of the covenant, the person that must perform it. A is the covenantee. The covenantee is the person to whom the promise is made, or, again, as it's commonly expressed, the person who has the benefit of the covenant. Now there's no doubt that the covenants we described, that A can enforce these covenants against B. A covenant is just a particular form of contract, and contracts can be enforced by the parties to it. This isn't controversial. Nor is it particularly interesting from a property law perspective. But let us take the example 1 or 2 stages further. Imagine that A sells Redacre to C. Redacre is described as the dominant land because it is the land which benefits from the covenants. And imagine that B sells Whiteacre to D. Whiteacre is described as the servient land because it is the land which is burdened by the covenants. And we describe C and D as the successors in title to A and B respectively. The question which arises, and which is interesting from a property law perspective, is whether C can enforce the covenants against D. Can C compel D to trim the hedges of Whiteacre? Can he prevent D from having barbecues in the garden of Whiteacre. These questions can be answered by applying the law relating to freehold covenants. In short, if the benefit of the covenants has been transmitted to C, and if the burden of the covenants has been transmitted to D, then C can enforce the covenants against D. It will not suffice if C has acquired the benefit of the covenants if D is not subject to their burden. Nor will it suffice if D is subject to the burden of the covenants, but C has not acquired their benefit. To reiterate, the covenants can only be enforced by C against D if C has acquired the benefit of those covenants and if D is subject to their burden. In a minute or two, we shall consider the circumstances in which a successor in title to the covenantee acquires the benefit of a covenant, and the circumstances in which a successor in title to the covenantor is subject to the burden of a covenant. It's necessary to make one last preliminary point. Freehold covenants are regulated by both the common law and equity, and the rules developed by each system are quite different. Thus, both the common law and equity have developed rules which regulate the circumstances in which the benefit or burden of a covenant is transmitted to the successor in title of the covenantee or covenantor respectively. In general terms, the equitable rules apply to restrictive covenants, and the common law rules apply to positive covenants. We shall see that equity is willing to allow the burden of a covenant to be enforced against the covenantor's successor in title. But we shall also see that the position at common law is in marked contrast to the approach in equity. The general rule at common law is that the covenant cannot be enforced against the covenantor's successor in title. We shall now proceed to consider the general rules concerning the transmission of the benefit and burden of covenants, both at common law and in equity. It's important to emphasize that the treatment here is not, nor is it intended to be, exhaustive. On the contrary, it's quite selective. In particular, it does not attempt to identify all the methods by which the benefit of a covenant can be transmitted. It does not consider the statutory jurisdiction to discharge restrictive covenants, and it does not consider the remedies available for breach of covenants. This lecture is not an adequate substitute for the recommended reading for freehold covenants which is set out in the module guide. Please ensure that you do that reading. In this part of the lecture, we shall identify the circumstances in which a covenant can be enforced in equity against the covenantor's successor in title. A covenant can be enforced against the covenantor's successor in title if four conditions are satisfied. It's worth noting that satisfaction of the first three conditions qualifies the covenant for recognition as an equitable proprietary right which affects the servient land. The fourth condition relates to the enforcement of that proprietary right against transferees of the servient land. This framework, i.e., one which involves identifying the defining characteristics of a property right and the enforcement rules which are applicable to that property right, should be familiar from other topics you have studied on the property module, for example, easements and leases. Let us consider then the 4 conditions. The first condition is that the covenant must be restrictive in nature. Equity only enforces restrictive covenants. A covenant is restrictive, as we noticed above, if it can be satisfied by doing nothing, by inaction. So, for example, covenants not to hang clothes from windows, not to play musical instruments, not to build above a stipulated height. These covenants do not require any action and can potentially be enforced in equity against the covenantor's successor in title. On the other hand, covenants to pay a sum of money, to mow a lawn, to repair a roof, or to paint a fence, they all require action, and none can be enforced in equity against the covenantor's successor in title. Equity does not enforce positive covenants. It only enforces covenants which are restrictive in nature. The second condition is that the covenant must benefit the dominant land. This condition comprises 3 related sub-requirements. The first sub-requirement is that the covenantee owned land when the covenant was made, and that the person seeking to enforce the covenant owns all or some of that land. The authority for this proposition is London County Council against Allen. So in our example that we considered earlier, this condition was satisfied. A was the owner of Redacre when he covenanted with B. But if, for example, a person sells all their land to a purchaser, and the purchaser covenants not to use the land in a particular way, that covenant cannot be enforced against the covenantor's successor in title, because the covenantee, the person who sold the land, did not own any land when the covenant was made, because he had sold all of that land to the purchaser. The second sub-requirement is that the covenant touches and concerns the dominant land. One of the leading authorities for this proposition is Marquis of Zetland against Driver. The most authoritative modern statement of a test for determining whether a covenant touches and concerns the land is to be found in P&A Swift Investments against Combined English Stores Group plc, a case which you may be familiar with from the context of leasehold covenants. In this case, Lord Oliver formulated the following working test. A. The covenant benefits only the owner for the time being of the dominant land and ceases to be of any value to the owner if separated from the dominant land. B. The covenant affects the nature, quality, mode of user, or value of the dominant land. And C. The covenant is not expressed to be personal. In other words, a covenant touches and concerns the dominant land if it is beneficial to the owner of the land in his capacity as the owner. Since this touch and concern requirement underpins a number of different rules relating to freehold covenants, it is useful to pause at this stage and to consider one or two examples of such covenants, examples which are taken from the case law. In Smith and Snipes Hall Farm Limited against River Douglas Catchment Board, E owned land which was situated between a brook and a river, and the land was susceptible to flooding. E and R made an agreement by deed. In that agreement, R covenanted to widen, deepen, and secure the banks of the brook, and to maintain them for all time. The object of the agreement was to prevent flooding of the land. The Court of Appeal held that the covenant touched and concerned E's land. The reasoning of Lord Justice Tucker is very concise, but it's also very clear. He said the covenant affected the value of the land per se because it converted the land from flooded meadows to land which was suitable for agriculture, and so in that sense it improved the quality of that land. Another case that we can consider is in re Gad's land transfer. In this case, E sold a plot of land to R. E retained most of the surrounding land, including a lane. The plot sold to R fronted onto and was only accessible from the lane. E granted R a right of way over that lane, and R covenanted with E not to build more than one private dwelling on the plot. Buckley held, that's Mr. Justice Buckley, held that the covenant touched and concerned E's land, i.e. it touched and concerned the lane. He noted that E was subject to a common law and statutory duty to keep the lane in repair. And he noted further that construction of more than one house on the plot would increase the amount of traffic over the lane. So he reasoned that the increase in traffic would generate a corresponding increase in the maintenance required to keep the lane in repair, with the result that the maintenance would become a more burdensome expense than it would otherwise be. He continued that the greater expense would make it more difficult for E to market and sell the lane. And he noted that if E was unable to afford to keep the lane in repair, there was a risk that the local authority would compulsorily acquire the lane and deprive E of his ownership. So in summary, Mr. Justice Buckley held that the covenant touched and concerned E's land, i.e. the lane, because it operated to reduce the potential expense of maintaining the land, and in that sense it rendered the land more marketable than it might otherwise have been, and therefore of greater value to E, or indeed to any other owner of the land. Moving on then to the third sub-requirement of the benefit, the dominant land condition. The third sub-requirement is that the dominant land and the servient land must be sufficiently proximate to one another. So they must be sufficiently close. The case law has not identified any particular distance as being sufficiently proximate, nor has it identified any particular distance as being too remote. Rather, in each case, the question is whether the proximity between the dominant land and the servient land is such that the restriction on the servient land is capable of affecting the enjoyment of the dominant land. To adapt a very well-known example, a covenant restricting the use of a house in London is unlikely to affect the enjoyment or value of a house in Glasgow. And for those who are unfamiliar with UK geography, the distance between London and Glasgow is approximately 420 miles. The third condition for the burden of the covenant to pass to the covenant or successor in equity is that the covenanting parties intended the covenant to run with the servient land. The authority for this is Morels of Oxford Limited against Oxford United Football Club Limited. In other words, it must be clear that the intention of the covenanting parties was that both the covenantor and his successors in title should be bound by the covenant. Since this condition is based on the intention of the covenanting parties, the first place to look for their intention is the instrument which contains the covenant. In many cases, the covenanting parties expressly manifest the relevant intention, where, for example, the covenantor covenants on behalf of himself and on behalf of his successors in title. In the absence of an express manifestation of that intention, the intention can be implied by Section 79 of the Law of Property Act 1925, unless the covenanting parties have excluded the operation of that section. The fourth condition is that the covenant can be enforced against the covenantor's successor in accordance with the applicable enforcement or priority rule. The enforcement rules have been covered in detail elsewhere in the property law module, and they will not be restated here. It's sufficient for present purposes to identify just one or two examples. So, where the servient land is a registered title, a restrictive covenant can only be enforced against a purchaser of that land if the covenant has been protected by the entry of a notice on the title's charges register, and that is the effect of the Land Registration Act 2002, Section 29. On the other hand, if the servient land, again a registered title, is gifted to a transferee, i.e. a person who does not give any value for that transfer, then the restrictive covenant can be enforced against the transferee because it predated the transferee's acquisition of the land. That is the effect of the Land Registration Act 2002, Section 28. So, as you can see, the enforcement rules which apply to a restrictive covenant depends very much on the exact nature of the relevant transfer, and of course on whether the land is a registered or an unregistered title. In this part of the lecture, we shall identify the circumstances in which a covenant can be enforced in equity by the covenantee's successor in title. A covenant can be enforced by the covenantee's successor in title if two conditions are satisfied. The first condition is that the covenant touches and concerns the dominant land. The second condition is that the successor acquires the benefit of the covenant by assignment, or by annexation, or by a scheme. The touch and concern condition was discussed earlier, and that discussion will not be repeated here. However, it is necessary to briefly consider the law relating to assignment, annexation, and schemes. Let us first consider assignment. In the current context, an assignment is the deliberate transfer of the benefit of a covenant from the covenantee to his successor in title. For example, on a sale of the dominant land, the covenantee transfers the land to the purchaser and also expressly assigns the benefit of the covenants relating to the land to the purchaser. So he effectively transfers the benefit of the covenants to the purchaser. There are two requirements for a successful assignment, and they were set out in Reunion of London and Smith's Bank Limited's conveyance. The first requirement is that the dominant land must be identified in or be otherwise ascertainable from the instrument which contains the covenant. The second requirement for a valid assignment is that the benefit of the covenant must be assigned contemporaneously with the transfer of the dominant land. In particular, a covenantee cannot transfer the benefit of a covenant affecting the dominant land after he has transferred the dominant land to a third party. He is effectively deprived of the benefit of the covenant when he divests himself of the interest in the dominant land. Let's now consider annexation. Annexation involves the notional and permanent annexation or attachment of a covenant to the dominant land. The result of annexation is that any person who acquires the dominant land automatically acquires the benefit of the covenant, because that covenant is attached to the land. There are three ways in which a covenant can be annexed to the dominant land. The first way in which a covenant can be annexed to the dominant land is by express annexation. The covenanting parties can expressly annex the benefit of a covenant to the dominant land by manifesting an intention to do so in the instrument that contains the covenant. For example, the covenantor can covenant with the covenantee and his successors in title with the intention of permanently benefiting the dominant land. This would be a clear express annexation. In order to effect an express annexation, there must be a reference to the dominant land, because it must be clear that the intention of the covenanting parties is to attach the benefit of the covenant to the dominant land. That is what annexation involves. implied annexation is relatively rare. At least there are very few reported cases on implied annexation. It's sufficient for us to note that it arises where it's clear from the totality of the covenanting party's transaction that the benefit of a covenant was intended to be annexed to the dominant land. The third method of annexation is statutory annexation. By virtue of Section 78 of the Law of Property Act 1925, the benefit of a covenant will be statutorily annexed to the dominant land if three conditions are satisfied, and these conditions were set out in Crest Nicholson Residential South Limited against McAllister. The first condition is that the covenant must touch and concern the dominant land, a condition we have already discussed and we will not discuss again. The second condition for the application of Section 78 is that the dominant land must be ascertainable from the instrument which contains the covenant. And the third condition for the application of Section 78 is that the parties have not excluded that provision, because it's clear from Crest and Nicholson that covenanting parties are free to exclude the operation of that provision if they choose to do so. So, for example, if it is clear from the terms of a covenant that it is only enforceable by the covenantee, this displaces the operation of Section 78 because annexation of the covenant to the dominant land, which would necessarily enable the covenantee's successors in title to enforce the covenant, would be inconsistent with the covenanting party's intention that it should only be enforceable by the covenantee. Thus, Section 78 in that particular example would be excluded. The last method by which the benefit of a covenant can be transmitted in equity is a scheme. In general terms, a scheme arises where plots of land are sold by a common vendor and form part of a larger housing estate. And there are two essential requirements for a scheme. First, the area of land which is subject to the scheme must be clearly defined. Secondly, it must be clear from the covenants that they are intended to be mutually enforceable by and against the purchasers of the various plots which form part of the scheme. In other words, it must be clear that the covenants were intended to create something in the nature of a local law for the area which is subject to the scheme. Having completed our treatment of the equitable rules, we shall now focus on the common law rules. And in this part of the lecture, we shall identify the circumstances in which a covenant can be enforced against a covenantor's successor in title at common law. In fact, the general rule at common law is that a covenant cannot be enforced against the covenantor's successor in title. This point was very trenchantly restated by the House of Lords in Roane and Stevens. But the general rule is subject to one exception. There are also a number of workarounds, but these are not considered here. The one exception to the general rule can be stated in these terms. A successor in title to a covenantor cannot take the benefit of a particular transaction without submitting to the corresponding burden of that transaction. This exception is commonly referred to as the principle of mutual benefit and burden. It is neatly illustrated by Halsall against Brazel. In that case, the purchaser of a house on a housing estate, who was granted by the owners of the estate easements over the estate roads, covenanted with the owners that he would contribute towards the maintenance costs of those roads. The purchaser subsequently sold the house to X. X continued to use the roads, but refused to contribute towards the costs of maintaining them. Mr. Justice Upjohn held that X could not take the benefit of the original transaction, i.e. the use of the roads, without also submitting to the corresponding burden of that transaction, i.e. the liability to contribute towards the maintenance costs. This principle of mutual benefit and burden applies if four requirements are satisfied, and these requirements are derived from Thamesmead Town Limited against Alotti and Davis against Jones. First, the relevant benefit must be conferred as of right. Secondly, the benefit and the burden must be conferred and imposed by the same deed, i.e. as part of the same transaction. Thirdly, there must be a sufficient connection between the benefit and the burden. In the Halsall case, which we considered a few moments ago, the connection was very clear and obvious. You can use the roads if you contribute towards the costs of maintaining those roads. But the principle does not apply if, for example, a person who is granted a right-of-way covenants to keep in repair the roof of the grantor's barn, because there is no connection between the use of the right-of-way and the roof's state of repair. They are completely disparate items. The fourth requirement for the application of the mutual benefit and burden principle is that the covenantor's successor in title must have a choice whether to adopt the benefit. This does not mean a practical choice. A theoretical choice is sufficient for this purpose. This too is illustrated by the Halsall case. In that case, X had no practical choice whether to use the road or not, because the road was the only means by which he could access his house. But nevertheless, the principle was still applied. Therefore, we can see that a theoretical choice is sufficient for these purposes, and it's not necessary that there is a real and practical choice available to the successor in title. In this part of the lecture, we shall identify the circumstances in which a covenant can be enforced by the covenantee's successor in title at common law. There are various ways in which the benefit of a covenant can be acquired by the covenantee's successor in title. These are set out in the module guide. We shall focus on just 3 methods, i.e., express and implied assignment and annexation. Let's first consider express assignment. A covenantee can expressly assign the benefit of a covenant to his successor in title. The general nature of assignment was discussed above in connection with the equitable rules. In order to effectively assign the benefit of a covenant at common law, the covenantee must comply with the requirements which are set out in section 136 of the Law of Property Act 1925, requirements which apply to the assignment of choses in action. You will see that effectively the assignment must be in writing, and the person who is subject to the obligation must be notified that the benefit has been assigned. Let's now consider the implied assignment of the benefit of a covenant. A covenantee successor in title will acquire the benefit of any covenants which run with the dominant land. This is commonly, albeit not invariably, described as implied assignment. The implication here arises by operation of law rather than by reference to the covenanting party's intention. So, in what circumstances does a covenant run with the dominant land? It runs with the dominant land if 4 requirements are satisfied. First, the covenant must touch and concern the dominant land. We have already discussed the nature of this requirement. Secondly, the covenanting parties must have intended the benefit of the covenant to pass to the covenantee's successor in title. They might expressly manifest this intention in the instrument containing the covenant, but in the absence of an express intention, the intention can be implied by section 78 of the Law of Property Act 1925, provided, of course, that the operation of that section has not been excluded by the covenanting parties. The third requirement for a covenant to run with the dominant land is that the covenantee must have a legal estate in the dominant land. And the fourth requirement is that the covenantee's successor in title must have a legal estate in the dominant land, but not necessarily the same estate as the covenantee. For example, if the covenantee holds the fee simple estate in the dominant land, it's sufficient for these purposes if the successor, in inverted commas, has a legal term of years in that dominant land. both the covenantee and the successor have a legal estate, albeit different legal estates in the dominant land. The last method for transmitting the benefit of a covenant at common law is annexation. We considered statutory annexation earlier in the lecture in connection with the transmission of the benefit of a covenant in equity. The rules that we identified there also apply in connection with the transmission of the benefit of a covenant at common law. In this part of the lecture, we shall consider how to structure an answer to a standard freehold covenants problem question, and we shall utilize that structure to preview an exam question. First, a general point. Problem questions should be answered using the IRAC method. This involves identifying the issue which falls to be resolved, identifying the legal rules applicable to that issue, applying those rules to the facts of the question, and stating a conclusion on the basis of that application. Try to use this system as much as you can. In a standard freehold covenants problem question, the dominant land and the servient land are transferred by the covenantor and the covenantee to successors in title. And what is said here is based on that basic model. In the absence of any specific instructions, an answer to a standard freehold covenants question, in the sense just described, can be structured in the following way. The qualification is important. If the examiner instructs you to deal with a particular issue in a particular order, you must follow those instructions. Indeed, always follow instructions which are included by the examiner. But let's return to a standard structure for a standard question with no special instructions from the examiner. The first thing that you should seek to do is to identify the issue between the parties. Who wants to enforce the covenants, and why do they want to do so? Next, identify which of the covenants are positive in nature and which are restrictive in nature, because you are going to apply the equitable rules to the restrictive covenant and the common law rules to the positive covenants. So in relation to restrictive covenants, apply the equitable rules that we considered earlier to determine whether the successor entitled to the covenantee can enforce the covenants against the successor entitled to the covenantor. So utilize those rules which we considered earlier concerning the transmission of the benefit and the burden of covenants in equity. If the covenantee successor entitled can enforce the restrictive covenants against the covenantor successor entitled, briefly consider what remedy the former will want and whether that remedy is likely to be available. If there are facts which justify such an analysis, you could also consider whether the restrictive covenants can be discharged under Section 84 of the Law of Property Act 1925. Once you have concluded these points, you should be able to state your conclusions on the enforceability of the covenants on the basis of the equitable rules. In the next part of your answer, you should switch your attention to the positive covenants and to the common law rules which regulate those positive covenants. Remember what we said earlier. Equity has nothing to do with the enforcement of positive covenants. Therefore, the positive covenants must be analysed by reference to the common law rules. So, in relation to any positive covenant, again, apply the common law rules which we considered earlier to determine whether the successor entitled to the covenantee can enforce the covenants against the successor entitled to the covenantor. If the covenantee's successor entitled is able to do that, identify what remedy is available to the successor entitled. In some cases, you will discover that the covenantee's successor entitled has acquired the benefit, but that the successor entitled to the covenantor is not subject to the burden. If you encounter a case like that, then you should also consider whether the covenantee's successor entitled can enforce the covenants against the covenantor, so the person that actually made the covenant in the first instance. Again, once you have addressed those various points, you should be able to state your conclusions on the enforceability of the covenants on the basis of the common law rules. So you have now treated both the restrictive covenants by utilizing the equitable rules, and you have also treated the positive covenants by utilizing the common law rules. It's worth saying a little bit more about one or two of these points. When you're applying the equitable rules relating to the burden of the covenant, it's important that you identify and apply to each covenant all of the conditions which were set out earlier in the lecture. And when you're applying the equitable rules relating to the benefit of a covenant, it's important that you identify which particular method of transmission you are utilizing, and that you identify and apply all the conditions which are necessary for that particular method of transmission. So, for example, if you are arguing that the covenant has been annexed to the dominant tenement, you must say so, and you must identify the requirements for a valid annexation and demonstrate that those requirements are satisfied on the facts of the question. It's not enough to merely assert that the benefit has been transmitted. This must be demonstrated, and the particular method of transition must be clearly identified. Of course, if you think that more than one method of transmission is engaged on the facts, apply the one which is the most obvious, or the one which can be dealt with the most quickly. In an exam, in particular, you are labouring under a time constraint. It's important that you are as efficient as possible. If, when applying the common law rules relating to the burden of a covenant, you think that the mutual benefit and burden principle is applicable, it's important that you identify and apply to the relevant covenants all the conditions which were set out earlier in this lecture. And when you apply the common law rules relating to the benefit of a covenant, it's important that you identify which particular method of transmission you are utilizing, and that you identify and apply all the conditions which are necessary for that particular method of transmission. And again, if you think that more than one method of transmission is engaged, go for the one which is the most obvious or with which you can deal the most quickly. Bear in mind that you may not always have enough information in the question to come to a definitive conclusion. In such cases, indicate the further information that you need and explain its relevance to the resolution of the issues which are in dispute between the parties. Now that we've identified the basic structure for a freehold covenants problem question, let's preview how to use that structure to answer an examination question. Please pause the recording, download the question from the VLE module page, and carefully read it. When you have done this, please resume playback of the recording. Welcome back. Hopefully you have read the question and you have identified some of the issues which must be addressed. Let's think about how to answer the question using the structure that was mentioned above. First, identify the issue between the parties. What covenants does C want to enforce, and what covenant might D want to enforce? Remember, you are asked to advise C, so frame the issues from her perspective. What covenant can she enforce? What covenant can be enforced against her? Secondly, identify which of the covenants are positive and which are restrictive, which require action, which can be satisfied by inaction. Be sure that you focus on the substantive nature of the obligation which is imposed by the covenant, rather than the form in which that covenant is expressed. Thirdly, to the extent that you are considering a restrictive covenant, consider whether that restrictive covenant satisfies the conditions set out earlier in our discussion for the transmission of the burden in equity. So ask yourself, is the covenant restrictive? Does it benefit the dominant land? Was it intended to be enforceable against the covenantor's successor in title? Can it be enforced in accordance with the applicable enforcement rule? When you're thinking about the benefit of a restrictive covenant, whether it has been transmitted to the covenantee's successor in title, again, ask yourself, which method, if any, of transmission is in play? And are the conditions for that particular method of transmission satisfied? Fourthly, if the restrictive covenant is enforceable, identify the remedy that the party with the benefit of the covenant is likely to seek, and whether they are likely to obtain that remedy. On the facts of this particular question, there is nothing to support an analysis concerning the discharge of the restrictive covenant, and so we shall omit that point. As you move into your analysis of the positive covenants, the common law rules, the sixth point that you should think about is whether those positive covenants can be enforced against a successor in title to the covenantor. Recall the general rule: covenants cannot be enforced against the covenantor's successor in title, but ask yourself whether the principle of mutual benefit and burden has any role to play in connection with any of the covenants. Consider also whether the benefit of the covenants has been transmitted to the covenantee's successor at common law. Again, which method of transmission is in play? Are the conditions for its application satisfied? If so, how? Seventhly, if the covenantee's successor in title can enforce the covenants, but not against the covenantor's successor in title, consider whether they can enforce the covenants against the covenantor. 8. If the covenantee's successor in title can enforce the covenant against the covenantor's successor in title, or indeed against the covenantor, identify what remedy is available. Now you should attempt to write a full answer to the question. Use the material above to help you structure your answer and to identify the principal issues. You will of course need to address and to answer the various questions which were mentioned in the preview above in order to write your answer. But please do not include any direct responses to those questions in your answer. Those questions are merely intended to give you a nudge in the right direction. Write your answer as you would write it for the purposes of an exam. Once you have written your answer, please share it with your classmates on the discussion forum. Hopefully your classmates will do the same. In any event, lead by example. Please use the discussion forum to comment constructively, respectively, on your classmates' answers. The function of the exercise is to generate a student-led discussion in which students learn from, get better acquainted with their classmates. In addition to the question which was previewed above, there will be added to the discussion forum another exam type problem question and other short form questions which raise a number of discrete issues relating to freehold covenants. Again, please actively engage with these questions. Contribute to the discussion. Share your ideas, your thoughts with your classmates, and engage and learn from their thoughts. A report on the discussion forum, together with an answer to the question previewed above, will be provided in due course after the discussion forum is closed. Thank you for listening to this Lecture Plus on property law